The court should apply the long-standing salutary rule that favors the party subject to the injunction when that injunction's meaning is uncertain or debatable. Oh, Judge, you didn't write a good injunction. The courts cannot review those because the president is empowered to make those decisions. That's how the system works, because we don't want a judge running the country.
We gave you a visa to come and study and get a degree, not to become a social activist that tears up our university campuses.
The Trump DOJ responds to Judge Boasberg, a very concerning judge out of the District of Columbia, and they came with the fury and the fire on this one, pointing out how the judge is so wrong to the judge, which is always fun. You can see this is in the case of the JGG plaintiffs versus Donald Trump, and these are the alleged Tren de Aragua gangbangers who were set to be deported. They were housed in Texas, but the lawyers, the ACLU gangbanger lawyers, like dozens of them, all came crashing into this from all over the world, like, we love terrorists, and we're helping them. I don't know how much they charged or what they're getting paid, but must be good. But they all sued in the District of Columbia, right? And they were saying that we need you guys to stop Trump from deporting these terrorists. Now, in the air, the judge said, turn those planes around. Those planes did not get turned around. They landed, and those individuals got a fuera right into El Salvador. And then the judge said, give me information and do these things. And then when Trump didn't do those things, after an evidentiary investigation, the judge called them down to the principal's office, which is what an order to show cause is. You're in trouble. I order you to show a reason why you violated my orders, why you didn't turn the plane around. You better have a dang good reason, or else you're getting suspended, bucko, and you're not going to prom or whatever. So sanctions, contempt, impeachment, trying to bait in and instigate a constitutional crisis that is Trump violating a court order when he didn't violate a court order. He was exercising his constitutional power as the duly elected president of the country. So Trump responded to this. They said, okay, you called us down to the principal's office. Okay, fine. Here, Judge Boasberg, you got this case. You got the conveniently assigned signal case as well. Here's the response. They say, listen, Judge Boasberg, on March 20th, you directed Trump, us, to do this. You said you have to come and show cause why they did not violate the court's TRO by failing to return the class members. And remember, this same judge certified a class of gangbanger Tren de Aragua gangbangers. A class! You see those commercials? You have mesothelioma in your lungs. Well, if you do, call this law firm. Think about that, but it's like, are you a Tren de Aragua gangbanger? Do you love smuggling humans and fentanyl into America? Well, call this law firm. We'll take care of you. And a judge will certify you as a class against the federal government of America. Certified them as a class and said, why didn't you return them? Why were they removed from the United States? This is the judge specifically. On the two earliest planes that departed on March 15th. Now, that directive, writes Trump, refers to flights carrying criminal aliens removed from the United States pursuant to Trump's proclamation, which was invoking the Alien Enemies Act about this terroristic gang. So these removals, Judge, I spent a lot of time reading that one paragraph, but it's pretty powerful. It's the first sentence is the judge wanted to know, why didn't you turn these planes around? Well, because they were criminal aliens who were marked as terrorists. That's why. Do I need to explain it further to you? We will. These removals are both complied with the law and they safeguarded Americans against members of a foreign terrorist organization. Now, the government will continue to defend the removals before this court. And if necessary, if you're going to continue to harass us about this, on appeal, challenging this court's two injunctions issued on March 15th. The first injunction, in a written minute order, entered before a class was provisionally certified, the class of gangbanger terrorists, enjoined the government and stopped the government from removing any of them for 14 days. Now, although that first injunction did not comply with the rules, and it did not state the reasons why it was issued under Rule 65 D1A, no one disputes that the government complied with that order, okay? And the defendants do not discuss it further. Okay, we complied. You said don't get rid of the 5 people who were a party of this lawsuit. And then the judge certified a class provisionally of all non-U.S. citizens in custody. One judge, all non-citizens in custody who were subject to the Tren de Aragua. Every Tren de Aragua gang member across this whole country now certified as a class by a federal judge in D.C. Now, the first one, we kept them in the country, okay? We didn't do anything with those people. But the second injunction, Judge, you issued via a minute order at 7:25 p.m. You said in writing, quote, the government is enjoined from removing members of the class not otherwise subject to such removal, pursuant to the proclamation for 14 days or until further order. Now, that minute order, again, did not comply with the rules, Judge. You have to state the reasons why. Rule 65 D1A. Read the rules. Regardless, the injunction thus bars the government from removing class members. It does not require the government to undo removals. See that? So the people in the air were already removed. It had already occurred. And for good reason, too, Judge. Even without the challenged proclamation, the president doubtlessly acts within his constitutional prerogative by declining to transport foreign terrorists into the country. Once they're in the air and out of the country, the president is not going to give an order to bring them back in. They're not going to get an order to come back. So that's just not going to happen. Here, any members of the so-called class aboard the flights had already left the United States when your minute order was entered and thus had already been removed. It had been done. No court has the power to compel the president to return them, and there is no sound basis to read the court's minute order to require that unprecedented step of taking terrorists once removed and bringing them back. And so the government fully complied with your terms, Judge, and everything you ordered at 725. That order purported to enjoin the government from removing class members under the Alien Enemies Act. But guess what? The government did not remove any class members after that time under the act. To be sure, the government had already removed some before the injunction. Some good lawyer wordsmithing here. These arguments always remind me of when my brother would stand in my door and put his hand in the doorway and just kind of annoy me. And I'd say, "Get out of my room." And he'd say, "I'm not in your room." I say, "Your arm is." He's like, "But I'm not." And he'd just stand there being obnoxious to me. I'm like, "I'm trying to study or something." "I'm not in your room." "Get out of my room." "I'm not in your room." Ugh, it's perfect. He was right. I was wrong. But nothing in the minute order suggested that the government had to return already removed class members to the United States. An injunction must be read in the context of its circumstances here. Here, the plaintiffs challenged the president's exercise to remove these people, but the president can. Alien Enemies Act says he can. Neither the injunction on which the injunction is based or anything else controls this. Now, when the Alien Enemies Act was enacted, the ordinary meaning of the word remove, Judge, just so you're aware, was to take or to put away or to place at a distance. Look at the dictionary for once. Look at this 1785 6th edition dictionary. And do you know how cool it would be to get a copy of that, like the original OG version? Samuel Johnson, Dictionary of the English Language. To put from its place, to take or to put away. That's what remove means. To place at a distance. And in 1795, the same thing. To put from its place, to place at a distance. 1790, same thing. Hadn't changed. Then you go to 2011. To move from a place or position occupied. American Heritage. Webster's. To move something from where it is. To lift, to push it. Black's Law. To transfer or move of a person from one thing or location. Okay, Judge, it's pretty clear what it means. The plain meaning of the word remove aligns with the context of the Alien Enemies Act. You said remove. We followed the same provisions. Now, it's understandably focused on removing enemy aliens. That's it. It's not about where they go after they depart our borders, meaning removal doesn't mean you get to bring them back. It's done. And so Trump complied with the court's injunction with respect to the two flights. Here's why. According to the gangbanger lawyers and Tren de Aragua gang members, those two flights took off approximately 2 hours before the court's minute order. And they did so from a location very close to the outer limits of the U.S. airspace, right? So now we're asking ourselves exactly where they were, right? So like if this is the Texas landmass and they're right here, which is kind of looking a little bit like chest. Okay, we're going to work on that. But if they fly out of there and this is the water, right? Here's the water. Those are waves. And that's the U.S. international waters line. So where are they? Before they land in El Salvador, which is the other landmass over here, El Salvador, right? Where are they? The judge says, okay, turn them around. Are they right here before they hit international waters? Or are they over here after they've already left international waters, right? This is why the judge wanted answers on all of that. And they said, we're not giving you answers to that. We're not telling you where they were. If it was water, okay, that's if it's water, if they're flying, let's say, over the Gulf of America. But maybe they're not. Maybe they're flying over landmass. Maybe they had to pop down somewhere in Mexico and then they had to pick back up and go over to El Salvador over here. And they're saying, we're not going to give you information about what our flight paths were or what interim countries we had to stop off in. Saying, as explained in the declaration, two flights carrying aliens being removed departed U.S. airspace before the court entered its order. And so accordingly, by the time the court issued its injunctions, the plane's occupants had already been transferred and removed. They're gone. The government thus did not remove any class members from the U.S. after you issued your injunction. Indeed, the government could not possibly have removed them from a place that they had already departed. Now, to be clear, the government did not order any removal flights to return to the United States. States. We didn't bring them back because it was done. But as noted, declining to bring class members back is not the same thing as removing them. So they were removed, and once you said stop removing them, we stopped. We didn't turn the planes around because they were already removed. As the injunction said nothing about class members who had already departed the country, there's no violation. Now, if any doubt remains, Judge, and none does, punk, the court should apply the long-standing salutary rule that favors the party subject to the injunction when that injunction's meaning is uncertain or debatable. Oh, Judge, you didn't write a good injunction. Maybe if you were more clear and concise and articulate with your language, we would know what to do, but we don't, and that's your fault. So here, the government enjoys that presumption since your injunction was so terrible, which underscores that the government complied. They also identified the gangbanger lawyers, a third flight that departed later. As the government has already disclosed, that flight carried detainees who were removable on grounds other than the Tren de Aragua proclamation, which is what they're suing about, and so it is therefore irrelevant. But in any event, Trump's DOJ continues telling us the 725-minute order failed to satisfy the rules. Judge, you did not state the reasons why you issued your injunction. Now, the order does not contain any such reasoning, only directives. And so it failed to issue the requirements for any binding injunction anyways. And in suggesting a violation of this order, the gang ACLU have focused not on the written minute orders, which we respected. Okay, when it came down in writing, we abided. But they're just trying to say that there were oral arguments and oral orders that you gave during the oral arguments on March 15th. They suggest that the court's oral statements, which were made available for viewing at the courthouse or purchase only the next day, should control, not the minute entry. And they're fixating on a handful of lines in the 46-page transcript when the judge said, return them immediately, and while leaving to the government the choice of how they accomplish that. Now, their argument is that even if the planes were already outside the United States, and even though the minute order only speaks to the removal and not returning them, the government had to turn around the planes with a terrorist mid-flight, because the gangbanger ACLU lawyers love them, based on the fact that the court's hearing began at 5, right? So, they started at 5, and so it should go back to that. But this argument ignores the law. It's well settled. An oral directive is not enforceable as an injunction. Read the rules. 65D says you must state the reasons why. That's why we want it written, so it's clear in writing, so it's not all this he said, she said stuff. This principle is deeply ingrained in case law. It's got to be written before it can be enforced as an injunction. And they're powerful common sense reasons why. The written order is more considered judgment. Oral responses from the bench may fail to convey the ultimate evaluation because judges can be wishy-washy. That was an inference to draw here. Ordering the government, like they're sitting there, these DOJ attorneys are going, what? Turn around a plane filled with terrorists into America? Like, are you crazy? We had a big problem with terrorists on airplanes once, probably, that they could have prevented, right? Maybe, I don't know. Now, indeed, that was a very reasonable inference to draw here. You want us to bring back terrorists, Judge, so they fly into buildings? What? Ordering the government to reverse an extant counterterrorism operation and deliver foreign terrorists to U.S. soil would have been an astonishing ultra-virus outside the scope exercise of judicial power and in conflict with basic law. When the written order did not include that command to turn the airplanes around filled with terrorists, the government could reasonably have understood that the court went back and they're like, I can't put that in writing, okay? I'm not going to order them to do that. And that is true regardless of how the government counsel understood the court's intent at the time of the hearing. And second, the rule says, write it. It requires the federal court frame its orders so those who must obey them know what to do, what it means, and what it forbids. Then it would undermine the principles of the rules if every syllable uttered at the hearing was a binding order. Got to put it in writing. Now, the court itself appeared to recognize that its oral statements did not amount to a binding injunction. Let's see. They're kind of calling the judge out. Just before explaining its preference that the government turn around the planes, the court also informed counsel that it would issue a minute order memorializing a TRO so you don't have to race to write it down. Saying, and immediately after the oral statement, the court further stated that it will issue a minute order memorializing all this. So the DOJ was reasonable to wait for the written order. Those promises accord with the rule that a court will ensure you have explicit notice of what is allowed and not. That rule is doubly important in cases like this this, where there are grave national security concerns and complex foreign arrangements. And even at the hearing itself, the court statements were inconsistent and contradictory, Judge. You couldn't even get your story straight. Just a few transcript pages before the above remarks, the court admitted, he said, well, once they're out of the country, I'm not sure what I can do there. Oh, yeah. Acknowledging that its jurisdiction ended at the border. And as noted, the gangbanger ACLU lawyers have asserted that the alleged deportation flights departed at 5:26 and 5:45 from a location very close to the outer limits of U.S. airspace. And then they assert that this court made oral statements on which they rely between 6:45 and 6:48. So turn them around at those times. So based on their own assertions, the flights left U.S. airspace. They were in the air for an hour, at least, before you made the oral pronouncement. So even by their own admissions, by their own timelines, those planes were well over the line in the diagram that we drew way up there. It says, under these rules, they agreed the court would clearly lose jurisdiction once they're gone, and they're gone. So under these rules, there was no need to wade into the thicket of parsing contradictory and imprecise verbal exchanges after the fact. That's why we have the rule. Write it down so we don't have to try to interpret what you were spouting off about for 40 minutes. This court should decline their request to transfer oral statements into a binding injunction. The law says write it down. What matters is the written order. And the court posted that 30 minutes after the hearing was over. Didn't take you long to write it. And moreover, even if the court's earlier oral statements were binding, because the rules require an injunction set out its terms, the court's written order would have superseded its earlier oral statements anyways. But either way, whether it was your oral order or your written order, we complied. Now, in all events, the president didn't even need to rely on the proclamation once the flights had left the United States. Once it crossed that line, that's gone. As explained, the government fully complied with the court's injunctions, but even if those orders had purported to prohibit a government from continuing to transfer class members who were already outside of the United States, they didn't get removed. They were already removed, and the transfer was continuing. Even if the orders could only be understood to be enjoining the conduct based on the proclamation. But forget the proclamation. The president has ample authority independent, aside from that, from the proclamation under the Alien Enemies Act, under Article 2, which is the Constitution, the supreme law of the land, to decline to bring foreign terrorists into the country. Sorry, Judge, just not going to do it. What's your power for that? The Constitution. I'm not an insane person who's going to fly terrorists back in, so sorry. Including by returning to the United States foreign terrorists who were previously in the United States. And so for that reason, our decision not to turn them around is in total compliance with the law. The president is entrusted with the vast powers in relation to the outside world. Once they're commander-in-chief, they're commander-in-chief. And these presidential powers that implicate national security and more are very powerful. This court lacks the authority to decide those cases that present those questions, right? The court can say what the law is within its jurisdiction. If the court can substitute its judgment for the president's judgment, then the court is the president, or the president's decisions to make. That's all. The courts cannot review those because the president is empowered to make those decisions. That's how the system works, because we don't want a judge running the country. And that's what they're doing now. They're stepping outside of their jurisdiction to wade into powers that they don't have. And the reasons counseling against courts intervening drop when they're outside the country. The president's ultimate direction of the flights at issue here, especially once they'd left U.S. airspace, implicated military matters, national security, foreign affairs. That's when the president's power is at the apex or the climax. Two consequences follow. First, to the extent that there was any ambiguity about the court's orders or about how the court's oral statements interacted with the subsequent written order, ambiguity should be resolved in favor of a reading that doesn't impose penalties for the writing of a terrible and vague order, because your order was terrible, Judge, and you wrote it like a moron. But also does not purport to interfere with the president's Article 2 powers, because the constitutional power is the greatest of them all, the supreme law in the land. Now, indeed, at the hearing itself, this court expressed strong doubts that its jurisdiction, even Judge, you admitted, you don't have power outside of here, outside once it leaves American soil. And so you cannot require anywhere on any power to force the president to bring terrorists into the United States. You're not going to do that, Judge, right? And even if the court disagrees with that proposition, the executive branch cannot be faulted for not interpreting this order to claim that we need to do that. And so we're almost doing you a favor, Judge. We're looking out for you. The court lacks authority to micromanage how the president decides to deal with terrorists, Judge. Simply, it's another reason to reject your order. And second, whatever else this court's orders may have done, they surely were limited to the use of the proclamation. They didn't reach the president's constitutional powers. Those were independently sufficient sufficient to support his removal of these people. Again, the minute order in no way directed the government to do anything outside the United States. You just said don't remove them from. They were removed. But at most, the court's injunctions and oral statements in the context of this litigation concern the invocation of the proclamation and the Alien Enemies Act. In other words, even if one could broadly and improperly construe the court's orders as restricting the government from turning over to alien enemies, right? Like it's not only removing, it's the handing over to Naib, or as governing other decisions, that was still limited to actions taken by the proclamation. But we don't even need this, right? This is the same thing we've been talking about, the independent power source. For the reasons explained though, Judge, once the flights were outside the US, the president did not need the proclamation or any act to get rid of the terrorists. At that point, the Constitution itself, Article 2, provided the president with the sufficient authority to act, and for that reason, any order that restrained the invocation of the proclamation could not have thereby compelled Trump to return them, foreign terrorists, into the United States. And any government refusal to do that from the president was not a violation of this court's orders. Okay, Judge? So the court should discharge this order to show cause. You wanted an explanation, Boasberg. You got it there, bucko. Because the government has complied with the court's orders in this case, obviously. And if the court concludes otherwise, the government respectfully requests the opportunity for further briefing. Signed in a very nice filing by Drew C. Ensign, baby, out of the Washington DOJ office. So, slamming that back to Boasberg. You call me down to the principal's office. Well, all right, here we are. Here's what we say about it. Now, the deportations, the arrests of these gangbangers will continue until criminality improves. Here was Caroline Levitt today talking about it.
I want to commend President Trump and our great Attorney General Pam Bondi, our FBI Director Kash Patel, and Tom Homan. This is what happens when you have competent federal leadership at the top, working with state and local law enforcement on the ground to put bad guys in jail. And this is a directive that has come from President Trump here at the White House to law enforcement agencies across the country. This president has your back, and he is going to support you as you pursue illegal immigrants and you pursue violent criminals in American communities. This individual who they arrested today was a national ringleader of the brutal MS-13 gang, a gang that the previous administration, Joe Biden and his cabinet and his team allowed to infiltrate in our country. And now President Trump and his team are cleaning up that mess by arresting these individuals. And this took place 30 miles outside of Washington, D.C., where you have politicians and mainstream media journalists who live in this city and who have derailed against the president and his crackdown on illegal immigration and on violent crime. They should be grateful that monsters like this are no longer going to be living in their communities thanks to the great leadership of President Trump and everybody who was on the ground. They were working throughout the night, no sleep for this team, to make the lives of the American people safe.
Getting it done out there. So that's Caroline Levitt. We also had It's Rubio out there, and Rubio was explaining more about this, saying you're not automatically guaranteed some sort of entry into our country, right? If you're here on a visa, if you're here on an invitation in any way, we have maximum power to get you out of this country.
We revoked her visa. It's an F1 visa, I believe. We revoked it, and here's why. I'll say it again. I said it everywhere. Let me be abundantly clear, okay? If you go apply for a visa right now, anywhere in the world, let me just send this message out. If you apply for a visa to enter the United States and be a student, and you tell us that the reason why you're coming to the United States is not just because you want to write op-eds, but because you want to participate in movements that are involved in doing things like vandalizing universities, harassing students, taking over buildings, creating a ruckus, we're not going to give you a visa. If you lie to us and get a visa and then enter the United States and with that visa participate in that sort of activity, we're going to take away your visa. And once you've lost your visa, you're no longer legally in the United States, and we have a right, like every country in the world has a right, to remove you from our country. So it's just that simple. I think it's crazy. I think it's stupid for any country in the world to welcome people into their country that are going to go to your universities as visitors. They're visitors. And say, I'm going to your universities to start a riot. I'm going to your universities to take over a library and harass people. I don't care what movement you're involved in. Why would any country in the world allow people to come and disrupt? We gave you a visa to come and study and get a degree, not to become a social activist that tears up our university campuses. And if we've given you a visa and then you decide to do that, we're going to take it away. I encourage every country to do that, by the way, because I think it's crazy to invite students into your country that are coming onto your campus and destabilizing it. We're just not going to have it. So we'll revoke your visa, and once your visa is revoked, you're illegally in the country and you have to leave. Every country in the world has a right to decide who comes in as a visitor and who doesn't. If you invite me into your home because you say, I want to come to your house for dinner, and I go to your house and I start putting mud on your couch and spray painting your kitchen, I bet you're going to kick me out. But we're going to do the same thing if you come into the United States as a visitor and create a ruckus for us. us. We don't want it. We don't want it in our country. Go back and do it in your country. But you're not going to do it in our country.
Yeah, we don't want it. Go back to your own country and cause a ruckus over there. One final clip from Tom Homan here.
A lot of people have is, how long has this person been in the country? And could the Biden administration have taken him down?
Of course it could have. I mean, the Biden administration, they tied ICE's hand. They didn't have our government approach, right? The FBI, doing things they shouldn't have done. But now they got Kash Patel there. You got Pam Bondi, great AG, who's making the FBI they're born to do, doing what they're supposed to do, chasing the bad guys, making this country safer. That's why this whole government approach makes so much sense. When we go on these operations, if we find an illegal alien with dope, DEA can prosecute him. We find him with a gun, ATF can prosecute him. FBI finds a domestic terrorism or terrorism investigation, they can prosecute them. So we can prosecute these people before we deport them. It's a game changer. President Trump's leadership, we've arrested more criminal foreign fugitives in this country, more criminal illegal aliens in this country in 2 months than Joe Biden did in an entire year. So game on.
Game on. Tom Homan, Pam Bondi, Kash Patel, all announcing new arrests. We've got Boasberg, who's being told it's none of your business what we do once they're out of the country. Take your little order to show cause and dismiss it, all right? Because the executive branch is doing what everybody should want them to do, which is to get bad people out of the country. But for some reason, these ACLU lawyers chomp at the bit to go represent them. So we'll keep our eye on this one, my friends. Thanks for subscribing and joining as we do.